Ladies first, pero nauna siya, mabilis rin tayo. Go ahead.
No, have we charged Jack Lam with corruption of public officials?
Mr. Chair, there is yet no charges against Jack Lam, but so far as the DOJ is concerned, but the National Bureau of Investigation charged him before the Ombudsman.
All right. So, Attorney Giran, for the record, meron na po bang kaso si Jack Lam regarding bribery or corruption of public officials?
Let me refer to the record, Your Honor. Section 3 of Republic Act 319 and Anti-Graft and Corrupt Practices. One. Another one is Presidential Decree number 46, making it punishable for public officials and employees to receive and for private persons to give gifts on any occasion.
Charge Jack Lam that?
One of those being charged is Dr. Yen Lok Lam, also known as Jack Lam, sir. Under the context.
Yeah, that's my question. So you charge him that?
Yes, sir, before the office of the Ombudsman. Yes, sir.
Sino yung sinarge yung binribe niya?
Under the context of conspiracy.
Come again, sir, come again.
Di ba may briber at saka bribee?
Yep.
Wrong English yun, ha? Yung tumatanggap at saka yung bibigay.
Bibigay po.
Sino?
Kasama po sila si Attorney Robles and Attorney...
Can we be clear lang, Attorney Giran? Sino ho yung charge nila? Sino yung charge in that?
Sinasabi niya si Consi.
Yes, so the two attorneys here, who else? Sila lang?
General Wenceslao Wally Asarcon Sombero Jr.
Ano ang charge yung kay Wally Sombero?
Together po. Together po.
Na siya nagbigay ng pera dito sa dalawa.
Opo.
Sino pa ho?
At saka si General Charles Toral Bacalima Jr. po. Under the principle of conspiracy po.
So you're saying that there is a conspiracy that occurred here.
Opo, sir.
Conspiracy between whom?
Among
Listas or the branch?
Among themselves, sir.
Huh?
Among themselves.
All four of them were involved with the same conspiracy?
Yes, sir.
Okay, well, I hope you prepare your case well. Okay. Senator De Lima?
Thank you, Mr. Chair. I wish to focus more or tackle certain policy questions, but I can't help commenting on just what I heard from the NBI. Actually, that was the point of my questioning last time when I asked NBI, sino na po yung mga kinasuhan nyo? And you did say that you filed the case against all of them. Argusino, Robles, Jack Lam, Sombero, Kalima. Hindi kasama doon si Commissioner Morente. Although, I don't know, maybe you have a reason. But that's problematic for me. Because you have here two versions of a story, both sides pointing to each other, and therefore, you have to determine, based on your own fact-finding, on your own evaluation of available evidence, which of the two versions is acceptable. And you proceed from there. Pero yung ginawa niyo po, parang, ano tawag doon? Shotgun. You charged all. Although technically, kung ganun ang sinasabi niyong conspiracy, since may sinasabi rin si Attorney Argusino and Attorney Robles na dun sa supposed na paghatian ng 18 million proceeds, yung share nila, meron pa dapat dalawa pa o tatlo pa na dapat isama. Commissioner Morente, Ramon Tulfo, and Mr. Chan. So what is the legal basis for charging all of them? You've got to uphold only one version of two conflicting stories and proceed from there. And then when you proceeded to charge all, hindi pa nga kompleto. So if you believe this is a conspiracy, the act of one is the act of all, and since other personalities are being mentioned as kasama sa hatian, sa partehan, incomplete pa rin yung ginawa nyo. But that is the basic defect that I'm seeing here. But you need not, are you ready to respond to that? And my next question is, did you clear the filing of that complaint directly with the Office of the Ombudsman, with the DOJ, specifically the Secretary of Justice? They could have reviewed that and pointed to you what they would see, if they can, that infirmity that I'm seeing.
We did not, ma'am.
Why? I don't think NBI is supposed to directly file anything without the clearance of the Secretary of Justice. That never happened before during my time.
We have also our legal division, ma'am, you know that. And as it can be gleaned now from the records of the case, the two respondents here, specifically Attorney Argosino and Attorney Robles, are fraternal brothers of the Secretary of Justice. So, ma'am, we do not want to burden some more the Secretary of Justice of having
Is that the
his
same
rights.
reasoning? Kasi medyo naguguluhan na po ako dito. Because that's not supposed to be the case. It's not the protocol. Is that the same reasoning kung bakit hindi nyo rin kaagad pinaalam kay Secretary Aguirre yung placing Mr. Sumbero under protective custody? I think it was not really cleared with him. You just advised him post facto.
We made notification about the
No, is that the same reasoning po? Na iniwasan yung humingi ng clearance from Secretary Aguirre because his fraternity brothers are involved.
with respect to Mr. Sombrero, ma'am, a case like this or situation like this is not normal in the Bureau. So we have to seek the approval or the clearance.
I think a lot is no longer normal in the Bureau.
Come again, ma'am. I'm
Just a
sorry,
side
ma'am.
comment
I'm
from
sorry.
me.
It's all right, ma'am. Thank you. I understand, ma'am. So with respect to this case, ma'am, this is not an ordinary matter every day. So we have to clear it with the
Yan
Department
na
of
nga po
Justice.
kasi yun na nga, nakikita ko mukhang may depekto ho yung pag-file nyo, kung sino yung mga dapat kinasuhan nyo. So
And-
probably if this went through the Office of the Secretary of Justice, because in the first place that is really the mandate of the Department of Justice, was as to which cases to be filed and which cases are not to be filed, who are to be filed, who are not to be who will be charged, who are not to be charged. That's essentially the prosecutorial function. Although diniretso nga ninyo sa ombudsman.
Can I explain on that, ma'am? Ngayon na naman kasi ito klaro, ma'am, because of this committee hearing. Before, hindi masyadong klaro because,
Alin po ang hindi klaro?
kung ano talaga nangyayari lahat, ma'am. Unlike dito po, this is a blow by blow, what we call this, relation of facts of what happened. Unlike, ma'am, in the investigation conducted by the NBI.
But that was the duty, the mandate of the NBI, precisely to conduct an investigation,
That's right, ma'am.
fact-finding.
That's
And
right.
on the basis of your findings of fact, evidentiary, you're supposed to make a recommendation to the Secretary of Justice.
I said it already.
So if that
earlier,
was
ma'am.
your action, if that was your, yes, that you're going to file it directly with the Ombudsman, that
Yes,
at
ma'am.
least clearance from the Secretary of Justice. So you did not do that.
Well, we inform, ma'am, the Secretary of Justice about
Okay.
the action.
As I was saying, I wanted to focus on policy issues or policy questions, although isang factual lang po. Kanina po, nung tinanong po pareho si Chair Domingo and si Secretary Aguirre about yung sinasabing meron ding attempt or some offer kay Chair Domingo, magkaiba ho ata yung sagot nyo. Secretary Aguirre said that you got it the information, you got it from Chair Domingo. Chairman Domingo, di ho ba? Nakausap nyo daw po. But we heard earlier, Chair Domingo, there's no such thing, the supposed offer from Jack Lam or the camp of Jack Lam. So, sino po ang nagsasabi ng tama ho dito?
Sa akin ho, wala hong offer kasi hindi po ako nakikipag-meeting ng hindi ko kasama yung team ko. At kung may sasabi pa na sasabihin kung sakaling may offer, lagi ko hong sinasabi, ilagay mo in writing, i-discuss natin.
Yes, but Secretary Aguirre said, we all heard it, that he got it from you.
Baka ho, we were...
Nakausap po kayo. So,
It might just be a casual conversation, but I don't remember.
okay, that's clear. The denial of Chair Domingo,
I don't.
to me, is clear. That she said no such thing. There was a similar offer to her from the camp of Jack Lam. But Secretary Aguirre po, so saan po nanggaling yon?
I might have misunderstood the chairperson, but that's what my notion after I talked to her, that
Is always a serious charge.
I recalled that
Secretary Aguirre, it's a serious allegation whenever you say that someone committed a crime or someone attempted to commit a crime, someone attempted to bribe. It's supposed to be a serious allegation.
I
So,
take
yun
I'm
lang
sorry,
ho ba
I'm sorry,
talaga
Your
ang
Honor.
style nyo?
I take it very seriously, but that's my impression when I talk to her. That
When was this po? May we
I-
know, when did you talk to each other? And you're attributing that particular impression of yours that there was a similar offer to Chair Domingo, but
I could-
which she denies.
I could no longer recall the date.
So hindi naman po siguro yun dun sa birthday party ni Attorney Fred Lim, the president of PAGCOR. I suppose, Chair Domingo, you were not there?
We were there. A lot of
Oh, you
PAGCOR
were there.
Yes, because he's an officer
So,
and her friend.
could it
so-
be on that same occasion? That's November 27 evening. That
No.
was already the day after the meeting of Secretary Aguirre
No,
with Jack Lam.
No, Mr. Chair. I believe that we talked before the September 27 of November, before on the birthday of Mr. Attorney Fred Lim. But I might
How-
have
so
I might
it could
have
not-
misunderstood.
Secretary,
I might
salamat
have misunderstood her when she said that yan nga ang sinasabi sa akin na 1%. Tapos sinabi sa akin ni chairperson na wag mo nang isabihin yung 1% na yan. You just pay the correct taxes.
Secretary Aguirre, so you said that it could not have been, to your recollection, hindi po during that same occasion, the birthday of Attorney Fred Lim, the president of PAGCOR. Although Chair Domingo just said that she was also present there. But Secretary Aguirre, sabi niyo po, hindi po, that was before.
It must have been on November 27, but before we met at the house of Fred Lim.
Yes,
As a
because-
matter of fact, in the house of Fred Lim, I met with Chairperson Domingo, and I joke about that 1%. So I might,
Yes.
if the chairperson is denying it, then let her deny
Yes,
it. But
because-
that's the way I understood her.
Yes, because-
before that.
Yes, Secretary Aguirre, I think you're done. It could not have been before November 27, right? It could not have been before November 26.
It is on November 27.
On the day of November 27.
But before the actual party.
before
it
the
night.
party. Because
It must have been daytime.
yes, because it cannot be before the evening or the afternoon of November 26 dahil dun nga lang po nangyari yung sinasabi niyong offer to bribe you from Jack Lam. Correct?
That's right.
Okay. Yes, Chair Domingo.
Ma'am, ang sinasabi naming 1%, kasi sabi ko, 1% lang ang binabayad ni Jack Lam sa junket. Dapat 10%. So, sabi ko, kailangan magbayad na rin siya ng 10%. But it was casual lang po yung, kasi it was a party.
Napakalayo po ng statement na yan
Oh,
for
kaya
any
nga po-
insinuation of any offer to bribe also.
Kasi po, kung sasabihin similar bribe, hindi ko alam
Napaka-wild
ano
ho
yung
pala
bribe
kasi ng imagination nyo, Secretary Aguirre.
Alam po ninyo,
Wala.
my imagination is really clear. Pero yung pong ganung pag-uusap lamang, I don't make so much about that. Nag-uusap lang kami siguro for a few, less than a minute. Tapos nabanggit niya sa akin, ako nga niya, sinasabihan na 1% ang gustong ibayad eh. So, ang sabi ko, don't mind the 1%, just pay. Sabi niya sa akin ni Chairperson Domingo, your legal obligation of 10%.
Chair
So if I
Domingo.
misunderstood her, then ako may kasalanan.
Chair Domingo,
But
you
it
don't
is a
have
mere misunderstanding.
You don't have to raise your voice, Secretary Aguirre. Relax lang po kayo.
Yes, I will relax.
Kayo lang pong dalawa nakakaalam exactly kung ano sinabi nga po ni Chair Domingo.
I-
Now, whether you misinterpreted her
I
or
don't know
not,
I don't know where this conversation is going. What is so important about that
Well,
kind
just
of
answer the
exchange?
question.
It was
just
a
answer the
very-
question, please.
I will either order a recess or you can both calm down or just rest
I'm not
easy.
raising my voice, Mr. Chair.
Well, but you're conducting the chair already when you're saying you've had enough. I don't think you should say that. Have a little respect for the chair. I am in control of these proceedings, and I'd like everybody to tone their voices down. And when I say that, I don't mean you. I said everybody.
I apologize, Mr. Chair.
Thank you. Apology is accepted. Please proceed.
Thank you. So we're going to hear from Chair Domingo again, please.
Yes, ma'am. It was a very, there were so many people. It was a very casual thing. And I was just saying na, for me, I will insist, hindi 1% ang babayad. Dapat magbabayad siya ng 10%. Ganun lang po yung ano. So, pwede po talagang hindi kami masyado nagkaintindihan dahil puno po talagang tao eh. And then, in passing lang ho. So, I'm sorry that I have to, but that is what I know, that yung 1% na yon nanggaling po na 1% lang talagang binabayad ni Jack Lam at nag-i-insist po kami na 10% ang ibayad niya.
Chair Domingo, I take your word for it.
Thank you po.
And it's what you call, it's res ipsa loquitur. Exactly what you said.
Salamat.
Res ipsa loquitur. So going now to the policy questions that I was supposed to ask. Tungkol naman po dun sa issue ng the license being secured under CESA. Hindi ko po alam if any of you, whether it's Secretary Aguirre or Chair Domingo or even the BI, na may opinion na po ako dyan eh. Or the opinion, the request for legal opinion for me, and this was sought by the late Secretary Jez Robredo in 2011. I received a letter from him asking for my legal opinion on, quote, whether or not the franchise granted by the Cagayan Economic Zone Authority, CESA, for the operation of High Alay Fronton in the Cagayan Freeport authorizes a franchisee to establish or operate High Alay online betting gaming stations outside the Freeport. So this may not be about really online gaming, more of online high alay. You know, the off-fronton high alay. Clear po yung naging opinion ko dyan. At ang sinabi ko po, hindi po sakop yan. May I just quote? After discussing the license of CESA, the license of PAGCOR, etc., and the applicable law, Republic Act 954, ang aki pong opinion dito, the mere fact of being a grantee of a legislative franchise to operate or maintain a fronton does not exempt said grantee from being penalized under the second offense. Yung second offense po kasi yung operator of a fronton who is a grantee of High Alay legislative franchise, the offering, taking of bets on any pelota game or event outside the place, enclosure, or fronton where the pelota game is held by a person, operator, or maintainer of a fronton with a legislative franchise. Section 5 of RA 954 only allows a high alay legislative franchisee to take bets within the fronton enclosure, but likewise penalizes him if he takes bets outside of the fronton where the high alay game is conducted. So dun po sa dispositive portion ko po, after explaining all of this, in my opinion, addressed to the late Secretary Jesse Robredo, ang sabi ko po, number 1, CESA is authorized to license and grant a high alay franchise to Meridian in accordance with the final and executory October 30, 2009 decision of the RTC of Apari, but so authorize Meridian to operate off-fronton betting/gaming stations only if it is allowed by law in accordance with CESA's own February 2, 2009 certification issued to Meridian. And number 2, however, since no law allows the operation of off-fronton betting stations, as in fact they are prohibited and criminalized under Section 5 of RA 954, Meridian can only set up its high alay betting/gaming stations within the premises of the place, enclosure, or fronton where the pelota game is held, that is, inside its high alay fronton located within the Cagayan Freeport Zone and nowhere else outside said fronton, in accordance with the terms and conditions of its CESA license as it was upheld in the cases of Meridian versus CESA and CESA versus Meridian. Tungkol ho yun sa off-fronton high alay. But this is very material because we're talking here about the CESA license na doon kinukuha even if the operation is outside the territorial jurisdiction of CESA. Unfortunately, dinala po kami sa husgado, kinasuhan po kami ni Secretary Jez Robredo, inakyat po kami sa Court of Appeals in a case Meridian Vista Gaming Corporation versus Honorable Leila De Lima and Jez Robredo. Nakakuha po sila ng TRO, nakakuha ng injunction. I don't know what is the exact status now of that case. I'm pointing this out po para tingnan uli ng DOJ if they would still affirm or they would be rejecting that opinion of mine, because this might be material relevant to this issue. Bakit ho nag-ooperate ngayon si Jack Lam? At sinasabi, wala sa inyong kinuha, you are insisting that it's covered, but as I said earlier, meron ding debate dyan sa coverage ng PAGCOR, or dahil nga yung sinasabi, narinig ko si Attorney Raymond Fortun, binanggit din ho ni ng chairman ho natin, na ang claim nila dahil sakop sila ng CESA. So paki-review lang po itong opinion ko pong ito.
Let me correct that impression. I was quoting Attorney Fortun as having said that the problem is that hindi na, yun ang inabutan lang kontrata. I mean, he doesn't mention CESA. He's talking about the loss leader that governments often give prospective investors who are prima para, first time, so that it will include, so that they can get more investors in. He wasn't referring to CESA. I was the one who referred to CESA. Sabi ko, CESA grants the license, but the BPO is being handled in Clark, which is something that we should explore in terms of violation. Right? Which we can tell Clark, huwag kayong pumayag pagka yan ay involving gambling. That's why I was telling PAGCOR should make representations with Clark or with CESA na hindi kayo papayag. CESA ka lang. Huwag kang pupunta sa Subic, huwag kang pupunta sa Clark, huwag kang pupunta sa Pasay or wherever you go. Okay?
I stand corrected, Mr. Chair, and I think I read somewhere quoting Attorney Raymond Fortun that he also mentioned something about that. They got their authority from CESA. And that's why I'm constrained to...
But not in the context that I said.
Opo. So I'm constrained to bring out this opinion of mine. Next point po, also on the policy side of things, Nabanggit ho pa ulit-ulit kanina na ang mga nagkaso dun sa mga ilang mga natira na mga Chinese nationals is the DOJ Cybercrime Office. I know about the office that was created during my time, although na overtake na po ng batas, Republic Act 10175. This is the Cybercrime Prevention Act of 2012. Pinaglaban ho namin ito noon na dapat medyo malaki-laki ang role ng Office of Cybercrime ng DOJ in the anti-cybercrime efforts of the government. Unfortunately, nung nakapasa na po itong batas sa Kongreso, I'm referring to Section 23 of the law that I mentioned. It says, there is hereby created an Office of Cybercrime within the DOJ designated as a central authority in all matters related to international mutual assistance and extradition. Wala hong grant of other powers like investigative powers, except that it is mentioned that that particular office, Office of Cybercrime of DOJ, would be part of the interagency body called Cybercrime Investigation and Coordinating Center, CICC, under the administrative supervision of the Office of the President. So CICC po ngayon, yung overall coordinating body on anti-cybercrime efforts or initiatives of government. So the Office of the Cybercrime, it would seem, under this law, has been restricted to its role as just the central authority on all matters related to international mutual assistance and extradition. But as to whether it can participate in actual raids, in actual investigation, that seems to be put under a cloud of doubt given this relatively new law. Pinaglaban ho namin yon, Mr. Chair, na sana mas broader yung mandate nitong Office of Cybercrime, but obviously the Congress did not oblige the DOJ. So any comment po from Secretary Aguirre? You might have overlooked this particular provision when you assign the Office of the Cybercrime to be the overall in terms of catching those engaged in online gambling at the Fontana.
Mr. Chair, actually, the Office of Cybercrime was there only to help, especially when many of those supposedly to be arrested have been escaping left and right. As a matter of fact, although this is the biggest raid with 1,316, we believe that around 800 of them escaped. And so we have to use all the available manpower of the office, and in view of the online gaming allegations later, we asked the help of cybercrime, the head of cybercrime, Mr. Sherwin Uy, to assist in the securing a warrant of a search warrant against one of the villas inside Fontana, and which was search warrant was obtained, and around 43 online gamers or workers were captured and were charged before the DOJ.
Which brings me to the clearer question. Does the Office of the Cybercrime, under the law, current law, have that mandate to apply for the warrant and also to file cases? Because as I said, it's very clear under Section 23 that it's supposed to be only in relation to international mutual assistance and extradition.
I don't think that it should be limited to that. I believe that because of necessity, If ever that is limited, but because of necessity at that particular time, we utilized.
In principle, I agree.
It's a judgment
Yes.
call of the Secretary of Justice.
In principle, I do agree with the good secretary here, because precisely as I said, we were pushing for a broader mandate of the Office of Cybercrime. But, so I think that's for Congress now to consider. There might be an amendment or a necessary amendment to make it clear exactly what the mandate of the Office of Cybercrime is. And we would appreciate the inputs of the DOJ in relation to this.
Yes, Mr. Chair. Yes, Senator De Lima.
Yes, the last policy question, this is in connection with my earlier line of questioning about the chain of custody of the 2 sets of cash surrendered. I think we need a piece of legislation insofar as that is concerned, because if I may ask the Secretary, what is the rule under current law in the proper disposition of money or proceeds of the crime? We assume those 2 sets of cash surrendered as proceeds of the crime because precisely cases were filed. So, General Kalima said he surrendered to CIDG, and it's still with the PNP. The Secretary of Justice said, the Attorney Argusino and Robles, they said they surrendered to the Secretary of Justice, confirmed by the Secretary of Justice. They even counted it, and then finally deposited in the vault of Land Bank. Now, a parallel question would be who would now, or who has now the control over those funds deposited in government bank? And then the cases are not yet with the court. So who would have the legal custody of these 2 sets of cash? What is the proper procedure for the surrender of bribe money?
Mr. Chair, may I reply, Madam Senator?
Go ahead, please.
Actually, when we receive that money, there is no such definite characterization that it is a bribe money. The 2 commissioners who surrendered it told us that these are evidence of corruption of public officers. So when we receive it, we counted it, and we were very careful after counting it in making it or in its original condition when it was surrendered to us for safekeeping.
Under whose name is the money kept in the safety deposit of the Land Bank? DOJ?
Madam Chair, it is under the name of the DOJ, and we did not deposit in the strict sense of the word before the Land Bank. It is in SDB or safety deposit box. We cannot or could not deposit it as an ordinary deposit before the Land Bank because it will be commingled with the money of the bank, and we might be destroying the some evidentiary value of this money.
So noon pong tinurn over sa inyo, as you said, wala pa naman hong indication that there could be a possible commission of an offense here, or there is bribery here, or corruption of public officials, because at that time you actually took the word of the 2 associate commissioners that these are supposed to be evidence, future evidence of the highest form of corruption. Now that all of these are coming out, now that they filed cases against each other, now that the NBI has filed its own case with the DOJ, what is now the true characterization of those 2 sets of cash Can we now consider them as proceeds of crime or a possible crime, and therefore what should be the proper procedure in the custody of those two sets of cash?
Your Honor, first I would like to correct the good senator that the money, that the cases filed by the NBI was filed before the DOJ. No,
with the,
it
with
is
the,
filed before the
ombudsman
Ombudsman.
Yes, yes. I'm sorry if
So-
I mentioned that. Yes.
And then may I go to one particular procedure that you mentioned a while ago, that why the NBI complaint did not pass the DOJ. Well, the practical reason was stated by the NBA Director Dante Gueran, but I would like to take exception to the fact that it is normal procedure, or it's the ordinary procedure, that all cases of the NBI passes through the NBI and needs our approval before the DOJ and needs the Secretary of Justice approval. It does not. Actually, only a very small percentage goes to the Secretary of Justice, and the NBI has been filing cases left and right directly to the courts or directly to the prosecution's office without passing through the office of the Secretary of Justice. It is not, that is the normal practice, and it is more or less not the normal practice that it should go first to the DOJ for approval.
I'm referring particularly to cases of import, to cases of public interest, imbued with public interest, high-profile cases, etc. Yes, I can agree with you there, Secretary, that probably not all the cases that are being filed by the NBI need to be cleared with you. Although during my time, I can very well say that a good number of the cases being filed by NBI would be cleared with me, especially high-profile cases imbued with public interest. And I think there's hardly any debate that this kind of a case is a high-profile case. So is it? So there's got to be another reason.
No, actually, I disagree with your assessment, Madam Senator. The case of Marcos for the killing of the Alvera Leyte Mayor
Espinosa.
It was filed directly by the NBI.
With the DOJ.
With the DOJ, but it did not pass through this representation for
Again.
approval. Many high-profile cases, for example, the cases filed by VACC, by the former directors of the NBI, La Sala and Esmeralda, by the thing. I believe that we did the right thing in filing those cases without passing through the Secretary of Justice.
The only issue here is on the clearance, the need for clearance with or by the Secretary of Justice. So I find it a little interesting that the policy has changed. High-profile cases, particularly the filing thereof, ought to be cleared with the Office of the Secretary of Justice.
Mr. Chair, I could not recall, or I do not know of any ruling or procedure which says that all NBI cases must pass through the Secretary of Justice. There's no such thing. And if the Honorable Senator was doing that during his incumbency as Secretary of Justice, I'm sorry to say that we are not following that in my administration.
All right. I would like to terminate this case for the day anyway, but we still have the BIR, and I still have some questions with immigration. First of all, I'd like the Immigration Commissioner to bring this agent, what is his name, who let Sombrero go?